There's also KRS guarantees lifetime pensions to public workers based on their highest years of salary, which I'm not sure why that's even in there, but there is a pensions. Kentucky state legislature likes to spend a lot of money on prisons and pensions. So we're spending lots of money on prisons and pensions when we're letting education and health care and job creation and roads and all the rest of the infrastructure, the internet and things that we need is being cut out. So the district court for a fast track for felony prosecution. So it's a felony probable cause hearing. That's the next step in this, is a felony probable cause hearing. It's a contested hearing before a district court judge. So it's in district court. The prosecutor presents witnesses to convince the judge that there is probable cause to believe that a crime was committed and that the defendant committed the crime. So this is the prosecutor's first go ahead, to prove this case. Here's my witnesses, here's what they say. He's guilty, he's guilty, he's guilty. So because the burden of proof is much less than a trial, the prosecutor generally doesn't call all potential witnesses to testify at the PC hearing, the probable cause hearing. Generally the victim and some eyewitnesses or the police witnesses. If there is no victim testify, there is no I'm the victim. There's no marks on them at all. There was no marks on my hands, but there was marks on their hands. So the burden of proof is less, though, but there is no victims. The police witnesses are there. Defendant has an attorney, can cross-examine the witness, so the defendant can cross-examine any of the witnesses the prosecutor puts up there. So the two officers are going to testify, so it'll be Joel Casey and Aaron Browning will testify, and then the defendant will cross-examine those witnesses, and then they can present their own evidence, including witnesses. They can present their own evidence. So after they cross-examine his guys, and then he can present me or some different evidence if he wants to. He doesn't have to. I don't have to testify this first time. If probable cause is established, the defendant's charges are referred to the grand jury. If the judge decides that there is not probable cause that the defendant committed the crime, the charge can be dismissed or reduced to a misdemeanor for trial in district court. So he can, wow, so okay, so he can dismiss all the charges. No, this ain't a crime, get out of here, I'm sick of this. Or he can try to accept one of the misdemeanors and then try the misdemeanor. I'm going to throw all of them out, but I'm going to say that you're guilty of menacing. I think you're a menace. So you need to go in there and you need to check out, you need to defend yourself against being a menacer or disorderly conduct or the other, well, not the two. So if they dismiss the felony, he would want to try it in district court. So if he reduces it to a misdemeanor, he'll try it. He would try it right then and there. So a probable cause hearing doesn't have to go to the grand jury. Defendants can waive their rights to a probable cause hearing wherein the charges are referred to the grand jury without any testimony or hearing. So I can just say, I don't even want to do this probable cause hearing. I want to go take it straight to the grand jury. So if it looks like I can't accept any misdemeanors, he needs to dismiss all of them. But if he doesn't dismiss all the charges, then I'm going to the grand jury. Most felonies arrive in circuit court after such a waiver. So after the grand jury is waived, or after the probable cause hearing is waived, then it says that they arrive in circuit court after such a waiver. So circuit court or grand jury proceeding. After the case is referred to the grand jury, the case comes to the Commonwealth's Attorney's Office, where it is assigned to an assistant Commonwealth's attorney. The assigned attorney reviews the case file, the defendant's prior criminal record, interviews witnesses, and determines if the charges are appropriate and should be indicted. So it goes to the grand jury, now it goes to their office, and now their office, the assistant Commonwealth's attorney, checks it out. At this point, the prosecutor can add new charges or add persistent felony offender charges to the final list of recommendations that will go before the grand jury. The prosecutor then submits the charges to the grand jury and subpoenas any relevant prosecution witnesses. So it goes to their office. If they think that there's enough evidence, then they go on to the grand jury proceedings. I do want to think about a little bit, if they said that was a misdemeanor, said they wanted to plead out. I mean, I can't even plead to like a jaywalking case, because if I pled to a jaywalking case, that would make it seem like I had done something wrong in order for them to confront me, but I had done nothing wrong. And in order for my hospital bills to be paid for, I have to get restitution, and the only way to get restitution is with a civil suit. They could just say, drop all charges and pay me what they should pay me for the medical side of this. I mean, it's already $15,000 to $20,000, and I'm not finished. I still have more medical work to do, you know? $20,000 just for walking down the street 1 block from my house, $20,000, and a broken face. That's what I got for walking 1 block away from my house. Going to the store, walking to the store in my own neighborhood, and get beat up, get jumped. Just get jumped out of nowhere, just for no apparent reason whatsoever. So, any testimony given by the defendant to the grand jury may be used against him in later court appearances. There's more about the grand jury proceedings. 12 citizens, and there's 6 alternatives from Jefferson County who served for a month. The hearing before the grand jury is confidential, not open to the public. At the grand jury proceeding, the prosecutor presents testimony through police or prosecuting witnesses. Yeah, so I wouldn't be able to accept, before with the probable cause hearing, I wouldn't be able to accept any, not even the I didn't even jaywalk, actually. I looked at the Kentucky's driver's manual, and if you're crossing an intersection and there's no stoplight, you can cross because it's an intersection. There's sidewalks there, you can cross there. You don't have to walk 15 blocks or whatever to find a place where they actually painted a crosswalk. And I've heard that jaywalking isn't even a crime in Louisville, but I don't know that for sure. But with the way that I've read, with at the intersection, you can cross an intersection, so that means you just couldn't cross at a non-intersection. You couldn't cross in the middle of the street, right? So, but I didn't do any of those, so I didn't even commit jaywalking. You know, they went ahead and put disorderly conduct and menacing, which are kind of like little misdemeanors. Maybe did it, maybe didn't. No, I didn't do that. I didn't even jaywalk. I didn't jaywalk. I did nothing. I did nothing. I did nothing. So walking on the street, crossing the street, all of a sudden these people are just cussing at me and trying to run me over and shit. Like, it was scary. It was terrifying. I had no idea who these people were. Who are you people? Why are you trying to run me over and cussing at me and getting out of the car and fighting and shit? Why is this happening? Why is this happening? So the hearing before the grand jury is confidential. It's not open to the public. At the grand jury proceeding, the prosecutor must present testimony through police or prosecuting witnesses. The burden of proof is identical to that of probable cause hearing. Whether or not there's probable cause to believe that a crime is committed and that the defendant committed the offense. So it's identical to the probable cause hearing. That's why I feel like if the probable cause hearing says that there is enough and it goes to grand jury, then that's just like a rolling rock that can't stop. So, you know, he might have to do it because he would want to get something on me, a misdemeanor or something. But if I won't accept any deal whatsoever, then he might say, well, I have to go to grand jury. So I guess a 75% chance that this will go to grand jury. Maybe at our request. So at the grand jury proceeding, the prosecutor must present testimony through police or prosecuting witnesses. It's kind of the same thing as the PC hearing, the probable cause hearing. The burden of proof is identical to the PC hearing. Whether or not there's probable cause to believe that a crime was committed and that the defendant committed the crime. So was there a crime? And did I commit the crime? That's the question. They're going to say, you know, did I commit a crime? Was there a crime committed, and was it me? And there is no crime committed, and so you can't blame, you know, the crime would be on them. They committed it. If the grand jury believes that there is probable cause, an indictment is issued and presented twice daily to the grand jury judge. If the grand jurors do not believe that there is sufficient probable cause, they can either remand the case to district court to be dealt with as a misdemeanor, or return a no true bill on those counts that fail for lack of probable cause. A no true bill is effectively a dismissal of the charges. So they can send the case back to district court with the misdemeanor, so they might try to get a misdemeanor on me anyways at the grand jury proceedings, or issue a no true bill, which is effectively a dismissal, which is a victory. However, the Commonwealth can present them again at a later time if new evidence becomes available. Defendants have no right to testify before a grand jury, but may request of the grand jury the opportunity to testify. So I don't have a right to testify at the grand jury proceedings, but I think at the probable cause, yeah, I can present evidence including witnesses. So that's another difference between the probable cause hearing. I can present evidence and witnesses, but at the grand jury, we can present evidence, but I can't testify unless they ask me to testify, which I would testify. And I don't know why they wouldn't want me to testify. I got no right to testify, but if the grand jury requests it, then I can have the opportunity, any testimony given by defendant to the grand jury may be used against him in later court appearances. Direct submission to the grand jury by the office of the Commonwealth's attorney. The Commonwealth Attorney's Office may submit cases to the grand jury for consideration without proceeding through district court. Direct submission to the grand jury by the office, so the Commonwealth's attorney could just send it straight to the grand jury. This proceeding is often used with an ongoing investigations taking place. The assistant Commonwealth's attorney can request with good cause that a bench warrant be issued for the arrest of the defendant. Once an indictment is returned by the grand jury, a letter is issued by the grand jury notifying the defendant the time, date, and location of their arraignment in circuit court, generally the following Monday. Trial. So when it goes to trial, it's a jury trial or a bench trial. Either the judge decides it as a bench, or it's a jury trial and you get 12 more people to decide the case. So a trial is a fact-finding adversarial proceeding in which the prosecutor must present evidence to prove the defendant's guilt beyond a reasonable doubt. So this is like in the court or in the movies, right? You have 12 angry men and the one man stands up for what he believes is true, and then he's able to switch everybody else around. So you got to be convinced of my guilt beyond a reasonable doubt. You would have to think that I intended, that my intentions was to swing at a police officer. You would have to, basically discount what I'm saying.